Hello, everybody. I do not think I've ever used phrases extraordinary, keep well, and keep safe so much in my life. I fear it may continue for some time. However, in that vein, I hope from King's Chambers and in particular the Public Law and Court Protection team, you and your families are well. The effects on our lives, without seeking to undermine it, must be comparatively negligible to that class of vulnerable society that we represent, namely those who lack capacity. Whichever side of the fence we sit, be it as litigation friend, acting for the local authority, CCG, or even acting for family members. And in fact, the issues are now, by reason of COVID-19, the issues are now greater in scope, complexity, and require greater scrutiny by us as lawyers. To this end, and an attempt to adapt to the status quo, the public law team here at King's have devised a short seminar to run you through some of the relevant issues affecting that vulnerable class today, including the amendments to the Care Act, the amendments to the Mental Health Act, practice and procedure during this difficult time, and issues relating to self-isolation, deprivation of liberty, and contact. There's no doubt that these issues are fast developing at a significant pace. It was only yesterday that I, in particular, was advising in respect to the British Medical Association's COVID-19 Ethical Issues Guidance, which essentially adopts the concept of capacity to benefit quickly. So essentially saying that most unwell patients may be denied access, such as intensive care or artificial ventilation, whilst recognizing that this test in itself would result in indirect discrimination, but would be a justified means by reason of the serious pandemic pursuant to the Equalities Act. There's no reference at all in this guidance about what happens when someone lacks capacity to make decisions about their medical treatment. Anyway, the issues are vast, but in an attempt to crystallize some of them, my team of panel members require no introduction. They're all superstars in their own right, and their achievements and accolades are well documented in independent directories and our website. But before I start, there are some matters of housekeeping. I'd be grateful if all of you can keep your microphones to mute, switch to your viewer to speaker on the top left-hand screen, submit your questions via the chat function on Zoom, which you'll find on the right-hand side of your screen, and please let us know in the future if there are any things you wish to hear about by way of a talk. But feel free to give us feedback by email afterwards. So without further ado, I'm going to hand over to Andrea Kelly, who's going to talk about how COVID-19 is affecting the Care Act.
Certain RAS score or anything like that. It's very clear that this should be done on an individual basis in consultation with the service users, with respect for the person, and as much as possible personalized to the person's own circumstances. The guidance, which was promulgated on Tuesday, my personal view is I think this is very much an initial attempt. I think it's extremely likely that this is going to continue to be updated in the coming days and weeks. I think this is, again, a lot of people trying to do their best under extraordinarily difficult circumstances, but the guidance in its current form is really not complete, and I'm sure there will be more on this to come, and we'll obviously try to keep things updated as best we can. In terms of the nature of the guidance, it is statutory guidance. The Coronavirus Act does allow the Secretary of State to put out statutory guidance. What's unfortunately unclear in the guidance as it stands now is its exact effect. From my reading of it, I do not think it's RICS guidance. I don't think it has quite the same impact as CARE Act guidance or LASA guidance, because it appears to be issued only as a piece of guidance that local authorities would need to have regard to. Local authorities are not obliged to act under guidance promulgated under this unless they are directed to do so by the Secretary of State. On the face of the guidance, I cannot see a clear direction asking to do so, but as I say, the guidance is very likely to be updated in days and weeks. So any local authorities thinking of deviating significantly from the guidance, I would say, are doing so at their own peril, because I'm sure guidance could easily be compliance could easily be directed at any point in time if it appears that local authorities are not complying with it. The new eligibility framework, this is something I cover more significantly in the handout, but the key point on it is that this is the standard of care which is typically afforded to people who do not have regular immigration status. Care is only to be afforded when when the failure to provide it is going to result in a breach of the person's human rights. The slide that we've got up now notes that the most common human rights which come up in this context are Article 2, the right to life, Article 3, the right to be free from inhuman or degrading treatment or torture, and Article 8. Article 8, the right to private and family life, is exceptionally unlikely to trigger it on its own based on existing case law. This is again something I delve into more fully in the handout, but cases in which there have been findings of Article 8 breaches, as far as I can find, have almost always revolved around a failure to comply with the statutory scheme, leading to a deprivation of care being not in accordance with the law. Article 3 is the one that comes up much more prominently in the reported cases in relation to this. Local authority social workers should have some familiarity with applying this framework, again, because it is the standard used most often for failed asylum seekers and other people without regular immigration status. Local authority social workers should have some documents existing on human rights assessments, which they are called to conduct from time to time. Obviously, it depends on the local authority. Some local authorities have this issue come up very, very regularly. Some have it come up much more infrequently. So those tools should be handy. From my own experience in advising on this, I think this is often an extremely difficult test for local authority social workers to apply, again, through no fault of anyone's, but it is a very fact-specific judgment made in the case law about it. It is not really clear in the same way that the CARE Act eligibility framework is clear as to what you're looking for in order to find a breach of Article 3. As I noted in the slide, Limbuela is the key case. There's a case called De Almeida, which was a high court case from 2012, which I've summarized at some length in the handout. Personally, I think this is one of the most helpful cases on Article 3 breaches, because there was a finding that the failure to provide care would result in an Article 3 breach to this person. He was a man who was in end-stage AIDS, who also had a number of other health conditions, including hepatitis and skin cancer. He was believed to be in the last 6 months of his life. There was a proposal that he should be returned to Portugal to receive care in Portugal. Ultimately, what the court found was that because it was unlikely that he would actually receive any care in Portugal because of difficulties within the social care system there, he would be left to be on his own in a state of severe pain, dying, and without any real access to care. That was found to be an Article 3 breach, and that's the sort of standard that most of the Article 3 breach cases are in. It is not enough merely to be street homeless to have an Article 3 breach. It is not enough merely that the failure to provide care would result in a shortening of the person's life. It has to be something above and beyond that. Now, what I would say is this is likely to be an area of case law that will develop extremely rapidly if care packages are frequently withdrawn under the Coronavirus Act. There are many, many clients of ours that we've had over the years who I do think the failure to provide care would result in an Article 3 breach to them. Thinking briefly to a case I advised on last year, a person who would be in a situation where they would be unable to toilet themselves, would be at severe risk of falling and being left on the floor for significant periods of time, and it would essentially be at risk of severe injury, pain, and by the terms of the Article 3 case law, degradation. To my mind, I think that would likely be an Article 3 breach. So it's not that the standard doesn't exist, but it is certainly a much more difficult threshold to meet than the typical CARE Act standards. The Aburis case was another one that was decided very recently. This is again the quote on the slide. The short form of Article 3 is that it would be an imminent prospect of serious suffering caused or materially aggravated by the refusal to provide care in that case. That's essentially the short form version of it. Just going on to the next slide on this, it is always a highly fact-specific analysis. One of the things that I think will also come up in practice on a very regular basis is looking at what support structure the person has around them. This is likely going to be a really key factor in determining whether care must be provided as a matter of entitlement or whether it's more of a discretionary choice for the local authority as to whether to continue to provide it. Recent case law had confirmed again that local authorities should be blind under the unamended CARE Act to the other social supports the person had to them. From an Article 3 perspective, those would become extremely relevant, because what we'd be looking at is whether the failure to provide care on its own would lead to the person suffering in an inhuman and degrading condition. If the person does have a family or friends or informal carers who are able to rally around them, that may be a very relevant factor in looking at whether they would actually be suffering that sort of degradation. The other issue that I just want to stress from the guidance was just published on Tuesday. It stresses very, very strongly, and in many ways takes a very different tenor from the Coronavirus Act as it was written, that local authorities should not take the decision to use the easements unless it was necessary. The power to meet needs remains, and local authorities should do everything they can to continue meeting their existing duties prior to the Coronavirus Act provisions coming into force. The powers are to be used as narrowly as possible. So again, on both sides of this, for those advising clients and for those on the local authority side, it should not be a quick decision to withdraw care packages. This should be done because it has to be done, not just because it can be done. And the guidance is very, very clear on that front. I would note a couple of things in terms of more specific points from the guidance. It does say that local authorities no longer have to conduct CARE Act assessments. From my perspective, I think it's extraordinarily difficult to see how local authorities could fulfill even the amended responsibilities without conducting some form of assessments. The guidance states that local authorities should look to some more flexible ways of operating, and they may not need to complete a full CARE Act assessment in the way that they would normally go about doing it, which is likely understandable under the circumstances, particularly where face-to-face assessments may become, in many cases, impossible, and there will likely have to be some creative working around that. That being said, local authorities will certainly have to make a determination as to whether there is a potential breach of human rights, both in new cases and in their existing cases, if they are proposing to withdraw care or if care becomes rapidly unavailable to the person. To my mind, that there has to be an assessment to do that. Otherwise, it is impossible to me to see how you could make a rational decision to withdraw care or not to provide care if there was no real information on which that could be based. There may again be more guidance put out on this, but to my mind, the withdrawal of the need to conduct assessments, I think, is somewhat illusory, because the entire system would cease to function in any meaningful way if no assessments were being done. Personalization and co-production, again, are stressed in the guidance that they should remain very key factors both in assessments and care planning. When assessments are being done, when care plans are being produced, even though they don't have to be, personalization and co-production should remain at the heart of them. The guidance also notes that local authorities, if they have incomplete assessments or assessments which are not conducted during this period, will have to do them at the end of the period in any event. Few more points. Information and advice duties remain in effect. The guidance stresses that these may become more important than ever. I would wholeheartedly agree with that, as there may be many people who may be in need of care and or rehabilitation during this period and who are looking for somewhere to go. My view is also that safeguarding duties are about to take on a particularly high importance at this period of time because of the number of people who will find themselves very vulnerable and potentially very ill. My view is also that when care is withdrawn or becomes available to the person, there has to be a safeguarding follow-up on this to determine how the person is doing. As I note, the human rights standard for eligibility is a very fact-specific one, and there would have to be some follow-up to determine whether what was projected to happen to the person on the withdrawal of care actually did happen or not. The only way that can be achieved is either by continuing assessment or by inquiries from the local authority in accordance with their safeguarding duties. The last point that I want to bang on about, and I apologize if this is something that I'm the only one who is bothered about it, but I found this extremely bothering, particularly from a cop lawyer perspective. The easements make a change to the eligibility requirement, which allow a local authority's obligation to provide care to a person lacking capacity to be discharged by a third party who has no decision-making authority under the MCA. What it specifically says is that where the person lacks capacity and the person or the person who is the decision maker has been informed that there may be a charge for care, the third party, if they are in a position to arrange for care on behalf of the person, can discharge the local authority's obligation to the person. To me, this is a clear violation of the Mental Capacity Act. I don't see how it is possible to vest this power entirely in one person who is not a deputy, who is not an attorney on behalf of the person, and they are allowed to make this decision, even if they don't actually go about arranging that care. My advice to any local authorities would be to tread extremely lightly on using that provision, and to ensure that if a third party is making the decision to refuse care from the local authority on behalf of the person with care needs, that the local authority has satisfied themselves that that person's human rights are not being breached and that care is being delivered in some adequate way and the person is not being neglected. One of the reasons I find it particularly troubling is because the only piece of information it seems that that person needs to know is that there may be a charge for care. It's an odd provision. Again, I think allowances have to be made to the speed at which this was drafted. But what I would say is that the MCA should continue to be the key tool for making decisions on behalf of people lacking capacity. A decision not to deliver a package of care that a person would otherwise be entitled to should be made in the person's best interest and not solely by a third party. I apologize, as I think I've been both speaking very quickly and not in time, but I'm hoping there's a few minutes for some questions.
Yeah, not at all. Thank you, Ariana. That was really informative and really groundbreaking changes. Paula asked this question: that has the Secretary of State indicated that the easement guidance has statutory force? And if not, can local authorities safely disregard it?
So the guidance, well, so I would say you can't disregard it fully. The guidance is issued as statutory guidance, and the Coronavirus Act makes specific provision that local authorities must have regard to guidance issued by the Secretary of State. Excuse me. It is explicit within the guidance that this is statutory guidance. It is issued under the Coronavirus Act, so local authorities must have regard to it. Where I find it more confusing is that the Secretary of State also has a power to direct compliance with the Act. On the face of the guidance, I cannot see that he has done that. As I noted in the handout, and again, going into this in more detail likely than is helpful at this moment in time, they note that they have that power and they state that it will remain under review. To me, I would say the silence on that point is saying that he has not yet directed local authorities to comply with it. However, where that is being kept under review, I would say local authorities should exercise extreme caution in taking any path other than following this guidance.
Super. Caroline also asked this question, which is: for existing service users in receipt of a package of care, surely the most recent review under the Care Act can be used to determine what their needs are and what needs must be met in order to avoid any breaches of the Human Rights Act.
I mean, I would agree. I think an existing Care Act assessment is certainly going to be the most useful document. Care Act assessments are generally of higher quality than human rights assessments on this front. That being said, it is a totally different standard, and this was confirmed in a Boris very recently, which was by Michael Fordham QC when he was a deputy High Court judge before being elevated even higher. And I would never disagree with anything that he said in terms of looking at the law in fine-grained detail, is he found that there was no relationship between the Care Act eligibility framework and the human rights framework on this front. So the Care Act assessment would certainly be an excellent source of information on the person's needs. I would say that that would be the guiding document, certainly in starting any conversation about withdrawing care, but it is a different question which is being asked than anything within the Care Act eligibility framework. And the fact that someone is eligible would not mean that it would be necessarily mean that it would be a breach of their human rights to withdraw a package of care.
Okay, super. I think there's one final question from our very own Simon, who asks that in relation to the guidance, will it be interpreted in a way in which it can be disregarded when it's necessary to do so?
I would say yes. I mean, I think that what it says with local authority, the specific controlling factor is that they must have regard to the guidance. It is, I would say, a purposefully chosen different set of words than the effective Care Act, the Care Act guidance, which is that local authorities must act under it. It is a lesser form, and to my mind, I would say that it is not Rixson guidance yet. However, the Secretary of State does have the power to revise this guidance at any point in time, and he has the power to direct compliance with it. If he directs compliance with it, I would say local authorities don't have the ability to do that. That being said, these are exceptional circumstances. Different local authorities will be hit in different ways, and the Rixson standard does allow for deviation from guidance under very defined circumstances on the back of a very good reason for doing so. But I would start with the guidance, certainly wherever you can, and really only view deviation as an exceptional thing to do.
Excellent. Thank you very much, Ariana. That was very informative. You have prepared a handout, a more detailed handout, which if it hasn't already been sent out, it will be shortly after this seminar. So we move to our next speaker, who's Simon Burrows, who will be speaking about the implications on the amendments to the Mental Health Act. Over to you, Simon.
Well, thank you. I haven't got a huge amount to talk about in terms of actual changes to the law, because I've had my eyes on Westlaw for the last 20 minutes just to make sure. But in fact, the Coronavirus Act amendments to the Mental Health Act have yet to come into force as of 30 seconds ago, except in relation to the provisions that relate to the Mental Health Tribunal in Wales. So what I'm going to talk about in relation to the Mental Health Act variations are actually going to be what is likely to happen rather than what has happened. I haven't prepared a detailed handout. Most of these materials are actually available on the excellent newsletter that Gordon Exel has been preparing, and which is available through the Chamber's website. But I'm just going to talk about the primary issues that are affecting the mental health world and how they're going to be affected. Can I just say, in relation to AMPs, I've been getting quite a lot of queries about AMPs. AMPs are, of course, approved mental health professionals, and they have a very important role to play in many of the actions that are taken under the Mental Health Act, including, of course, the process of detention. And there's a lot of nervousness amongst local authorities about whether they're going to have enough AMPs to do the work that they think they're going to have to do. There's been a shortage of AMPs for many years, and I think that local authorities now are wondering how they can bring in new AMPs, renew old AMPs, and try to do it as speedily as possible. And there's just a couple of things I'd like to say at this stage about that, because it may be cutting off a source of revenue to me for advice, but it may well be helpful for some people to know this. The regulations under the Mental Health Act, which are specific to AMPs, set out in painstaking detail what the knowledge base AMPs have to have in order to become AMPs. There is no specified way of achieving that, although over the years there have been courses run and the like to make sure that AMPs are trained up. The regulatory bodies that deal with social workers, who are 95% of AMPs, and also the other professionals who can become AMPs, of course, regulate entry that way. But in fact, as long as an AMP is educated in the specified skills to an appropriate level, they can be approved. The approval lasts for 5 years. It cannot be extended. That's something I've been asked. It can be reapproved. It can be renewed. And as long as the person who approves or reapproves is satisfied that the AMP has complied with the training requirements during their period as an AMP, then they can be reapproved as an AMP. And as far as the validity of the status as an approved AMP when it comes to working for other local authorities, and I've seen this where a number of local authorities in the same area want to use the same AMPs, even though they're approved by different local authorities, then there's nothing to stop that from happening, as long as you have a contract saying that the person can be used as an AMP by them and you instruct them when the need arises under the Act. All this is anticipatory for the tsunami of cases that are anticipated in the wake of the COVID-19 pandemic. And that brings me on to the implications of the Coronavirus Act 2020 and the proposed amendments for the Mental Health Act. And it's worth realizing what the purpose of the Coronavirus Act is. It's to try to make sure that the available health and social care workforce can be increased, that there is a lesser burden on frontline staff, and then, of course, things that are not necessarily directly relevant to mental health services, like containing and slowing the virus, is obviously one of the objectives. The anticipation is that there's going to be an awful lot more work for mental health professionals, not just AMPs, but also social workers, nurses, and clinicians. And for that reason, under the Act, there is a marked loosening of the requirements which are designed to protect the rights of those who are, will be, and have been detained. And so in the amendments, for example, the need for 2 doctors to initiate the sectioning process under sections 2 and 3 is reduced from 2 to 1. If it is impracticable or would unduly delay the application. That is quite a relaxation of an important safeguard, particularly since the process of detention will now be carried out largely by telephone, with AMPs having to query with one doctor whatever it is that they want to query with them about the diagnostic criteria. The AMP will have to make decisions having not had what they would in the past have regarded as an adequate opportunity to examine, but being forced into the position by circumstances. And these new provisions are designed to make things a lot easier for the AMP and also to take the strain off psychiatrists who would otherwise be having to act as approved doctors. So there are other things as well. The detention period under section 5.2, which is for somebody who's in hospital, goes from 72 hours to 120 hours. That's when a doctor does it. And then when a nurse does it, which is section 5.4, goes from 6 to 12 hours. Both of those are, of course, designed to hold a person for such time as is necessary for them to be detained under the Act. In relation to the criminal justice process, a person who is detained under sections 35 and 36 cannot be remanded for more than 12 weeks in total at the moment, but that rule has now been removed. And something I saw from an AMP today, which I found very interesting and quite concerning, is that at the moment there is a problem for people in the community having contact with those patients who are actually in the community at the moment and are either former detained mental health patients or patients who may in the future become detained, because the amount of contact that is taking place, even through telephone, is now extremely low. So this is what gives rise to the fear that there's going to be a huge increase in the number of patients who may be in line for detention. Although, of course, the problem with that thesis is the number of beds available in psychiatric hospitals for those would-be patients is not going to actually increase. In fact, if anything, it's likely to decrease at the moment as the need for beds for physically ill patients is increased. Can I move on just to deal with other things that have changed, which is the administration of medication without consent, which you just have to say it to realize how serious it is. One of the great safeguards for that is the SOAD, the Special approved, sorry, I can't even remember what it stands for now, the specially approved doctor. And they are supposed to certify under section 58 that some treatment is given to the patient, and they have to make decisions about whether the patient has the capacity to consent or not. What these powers do, and you can read them, they haven't come into force yet, is to reduce the need to rely on the SOAD. The SOAD doesn't have to consult with so many people as before, making the overriding of a patient's consent more likely. Moving on to police powers, the police are likely to be very much in the front line if there's going to be a decline in people's mental health and the need to use the Mental Health Act to control them. At the moment, they have two sets of obvious powers under section 135 and 136 of the Act. One, of course, is where the police can enter a private place with a warrant given by a magistrate to take a person into a place of safety. And the other, which is section 136, is where if a person is in a public place and they're conducting themselves in a way that leads the constable to think that they need to be placed in immediate care or control, then the person can be removed and taken to a place of safety. At the moment, the limit of time in which that person can be kept in a place of safety is 24 hours from the time of removal or detention, but it's going to be increased to 36 hours. Although there's been a great movement towards trying to ensure that patients who are taken under section 136 or 135 are not kept in inappropriate places, I can't see that that is going to be upheld in the future, at least during the COVID-19 problem. I can see patients being kept for 36 hours in wholly inappropriate places. And these rules simply increase the length of time that those people can be kept wherever they are. It's all on the fact sheet on the Chamber's website. It isn't law yet, but it will be soon. What is law under the Coronavirus Act is that the rules governing the constitution of the Mental Health Review Tribunal for Wales have been changed, and they've been changed to be aligned with those that are in place in England under the Pilot Practice Direction, which came out a week or so ago from the senior president of tribunals, Sir Ernest Ryder. Those of you here who practice in the Mental Health Tribunal will probably already know this, but I'm going to tell you again anyway. This practice direction is in place for 6 months or such period shorter than that it's necessary. So if after 3 months it's not necessary, it may go. The constitution of the Mental Health Tribunal, both in England and also in Wales, is generally 3. It's a judge, a lawyer, obviously, it's a consultant psychiatrist, and what is known, used to be known as a lay person and is now known as a specialist member. They're often called specialist lay members, which is a bit of a contradiction in terms. But in any event, those 3 members are now reduced to 1. It's going to be just a judge sitting on his or her own. There will be a lot of types of case that will be conducted without a hearing. Most references, automatic references to the tribunal, those that concern community patients who are over the age of 18, references that concern community patients over 18, should be on the papers unless it is inappropriate, or if the parties agree, other cases can be dealt with on the papers as well. One of the other safeguards for a patient is the right to ask for a pre-hearing review in which they're seen by the medical member of the tribunal. Well, obviously those aren't going to take place if there isn't a medical member of the tribunal. And in fact, even if there were a medical member of the tribunal, they are now not to take place. So that removes a safeguard as well. Interestingly, non-legal members will be made available to the judge if the judge wishes to consult with them during a hearing. I can understand that there may be a case where there's a complicated medical issue, perhaps a diagnostic issue, that the judge may wish to speak to the consultant psychiatrist who would otherwise be sitting with him. And the way that that would take place is that a full record would be made of the conversation between the judge and the medical member, and that would then be repeated to the parties so that they knew exactly what had been said. I have to say, I'm not sure how much use is going to be made of this, because the medical member who's sitting in an office somewhere will not have met the patient, will not have read the papers, and won't necessarily be able to give very much assistance other than very general assistance about, for example, diagnostic criteria or whatever. At the moment, the situation is that listing cases is very difficult. The administration has been depleted. Everything is now being done electronically, which poses administrative issues of their own. But as I understand it at the moment, Section 2 cases, so the short, urgent section cases, are being conducted as a matter of urgency, as are those that relate to recalls of conditionally discharged patients, which again are urgent, and those involving people under the age of 18, CAMS cases, are being listed as a matter of priority. I think we've just about reached the stage now in the list and in the listing where Section 3 cases are starting to be listed. If you've got a CTO or a guardianship case, or indeed a conditional discharge case where the patient is in the community, then I think at the moment you can forget it if it comes to getting the case listed as a matter of urgency. So I don't know if there are any questions on that rather rapid sprint through the amendments, both to the actual law and also to the procedural law. But I can see that there are a lot of problems waiting to happen over the next few weeks as the spike, hopefully, is reached in this virus.
Thank you, Simon. That was fabulous. We've had quite a few questions, but given the time restraints, I'm going to select two, if I may, diplomatically. So if I could ask you this question from Lisa. She asked, does a AMHP have a duty to assess in person or use an alternative method, possibly such as telephone or a Skype consultation? And she's saying that we are finding some patients are not exercising safe practice in distancing, etc.
Well, the AMP has to assess. And at the moment, the assessment process, if it can't take place in person, which would mean at a distance, then it will have to be facilitated using either a phone or indeed what we're doing at the moment. And that's the problem. Usually, AMPs will have to assess people in the community, which I don't think necessarily gives them safeguards. And I know some of the AMPs are very concerned that unless they're provided with personal protective equipment, then they will be unwilling to go into somebody's house, even with a police escort. Police officers presumably will also not have protective equipment either, because nobody does. So I think that the answer is they'll have to do what they think is appropriate, and that's likely to be remote. Yes,
which follows on to this comment by a person who hasn't put his name, but has put his indication as 46786, who says he sits as a mental health judge, And the comment is that the chance of me discharging a person I cannot see is relatively remote. Why aren't arrangements being made for a video link hearing?
Well, that's a very good question. And in fact, I can tell you this, I also sit as a mental health judge. And I did a hearing just before we were all locked up, in which there were 7 lines leading into wherever they led, some virtual courtroom that doesn't actually exist in space. And there were 7 lines, 3 members of the tribunal, consultant, the care coordinator, all in separate places, and the patient, who was an elderly lady with schizophrenia, was in a room in the hospital with the nurse. And the whole thing went very well in the sense that we got through it 2.5 hours, excellent. But afterwards it did occur to me, what does an elderly lady with schizophrenia really think, sitting in a room with her nurse, with a box in front of her, with all these voices coming out? I can't imagine what that must be like for somebody with a profoundly serious mental disorder. But I take what the judge says. It's quite difficult to assess a person without seeing them. I don't know why they're not using even this fairly easy technology to have visual hearings. I really don't know. And I think that's a question that needs to be asked. I mean, all you need is a laptop and the software, and all of a sudden you've got yourself a trial. So I'm afraid I can't answer that question.
Sure. Thank you very much, Simon. I'll move on now to our 3rd session, which deals with practice and procedure in the Court of Protection in light of what's going on. I think, like most people, I receive daily guidances from the Vice President in terms of how things should be done by way of telephone or video. So Sophie Allen is going to take us through the latest updates and tell us what we need to do. Sophie.
Thank you very much, Sam. Yes, my little talk is just going to be a canter through some of the changes taking place in court with regards to practice and procedure as a result of COVID-19. Just a warning to Sam, actually, because Sam's got control of the slides, is that obviously I'm very conscious of time constraints and everyone's time constraints here tonight. So I'll be jumping from slide to slide quite quickly, I think. So
I'll concentrate.
Thanks, Sam. So I don't take up too much of your time. As Sam just said, I'm sure that all of you, like me, over the last 2 weeks, have had a multiplicity of emails and notes and guidance from different courts and different judges, all saying slightly different things and changing on a day-to-day basis as the COVID situation developed. And I can't, whilst I can't speak for anyone else, if any of you are like me, I think trying to carry out your normal job, learn to do it remotely, and digesting all of this guidance has been virtually impossible. And so fortunately, for us working in the Court of Protection, there now, as of Tuesday, is some fairly definitive and fairly comprehensive guidance from Mr. Justice Hayden, which really contains pretty much everything you need to know at this stage, with the caveat that it has within that, which it may well be updated or replaced at any time, in which case the new guidance is to be relied upon and it's to be considered entirely otiose. There is also, I should say, for completeness, other guidance been issued in the Court of Protection and also some cross-jurisdictional guidance as well. But really, Ms. Justice Hayden's guidance is pretty thorough. The key messages are firstly to ensure that those who lack capacity don't become more disadvantaged in the current situation than their capacitous counterparts. And secondly, as seems to be a case across the board, across all jurisdictions now, that there are to be no hearings requiring attendance unless it's a genuine emergency and it's not feasible to conduct a remote hearing. In terms of platforms, I'm sure everyone is becoming, if they weren't already, increasingly familiar with the various platforms that can be used. I suppose two things perhaps to point out from the guidance. I had understood it that Skype for Business was to be the judicial go-to, as it's installed on all judicial laptops apparently. However, you can in fact use any appropriate means of remote communication. So you can use Zoom or FaceTime or Meet Me, provided that the judge who's dealing with your case has got the appropriate software or hardware on their laptops, and they can do that, and providing of course that whatever you use has got the capacity to record it and be secure and GDPR compliant. The other thing to point out in terms of platforms, and which is made very clear in the recent guidance, is that for the purposes of the current situation, a hearing can take place by way of an exchange of emails, and that's to reflect the fact that there's an even more heavy emphasis on trying to avoid attended hearings if possible, and agree matters if it can be done in a way that's effective and that deals with all the issues appropriately. And to that end, you can have an effective hearing by email. If that's something you can do, this that can be done feasibly. So in terms of hearing etiquette, as of today, it sets out quite clearly that if you're not speaking, you should set your microphone to mute. And whichever judge is hearing the case has got discretion regarding how they deal with interruptions. As I'm sure everyone here today would already know, there's an onus on reducing a background noise, not being interrupted, and ensuring that your audio video is working before the judge joins the call. Although certainly my experience over the last 10 days in conducting hearings remotely is there's been much more of a flexible approach and much more accommodation with regards to things like that, and everyone trying to feel their way with the technology. There is scope to get more time, but you need to maintain the email communication with the judge or clerk, and there's an expectation that all the parties, whether lay or professional, as well as their legal representatives, should be participating in the hearing. In terms of technicalities, there's a requirement for minimum bandwidth, which not everyone is going to have at the moment, and there's a requirement that hearings have to be recorded. As I understand it, there are urgent steps being taken at the moment to try and implement a cloud video platform, which is hoped to be in place in the coming days or weeks, so that hearings can take place via cloud rather than on hardware. Skype for Business, which I'm sure everyone's becoming, if they weren't already, very familiar with. The judges are now all trained in using Skype for Business, which they weren't 10 days ago. No account is needed. You can record on Skype Business, although there's no uniform procedure or protocol for storing the recordings, and that's being urgently reviewed as we speak. There's apparently no way of avoiding everyone's email addresses, including the judge, being visible to all the participants. So again, that's something that's presumably being looked at the moment. And apparently Mr. Justice Mostyn has identified a quirk or corruption within it, which means, quite unsatisfactory, the recording's got to be restarted every 30 minutes. To avoid that. A disadvantage of the Skype for Business, which has been identified, is there's no scope within that for a side meeting or breakout room. So it's more difficult to take instructions on that platform, take instructions confidentially on that platform than it is with some of the other platforms that are available. Other platforms that can be used, Microsoft Teams, which is also installed on the judicial laptops, apparently. The scope for multiple team rooms in that to allow private meetings. Zoom's FaceTime life size are not set up on the DOM1 judicial laptops, which I understand is a laptop that's used by a lot of particularly family judges, but it's got quite limited scope for the software. But those platforms have apparently already been used in a number of cases. As I'm sure you all have heard this week in the media, there are concerns about the security of Zoom, but at present the official position is that the security of Zoom is acceptable, so it is an acceptable platform for a remote hearing to be conducted. And as well as that, Zoom, Skype for Business and Life Size are all GDPR compliant, and whilst the position with regards to Microsoft Teams apparently needs clarification, Ms. Justice Hayden has said that at the moment a fairly lenient approach is being taken to that in the current circumstances. Telephone hearing, there isn't a requirement that the default position, while there's a default position that hearing should be remote, it isn't specified as far as I can see whether there's a preference for a video hearing or a telephone hearing. What it does say is that if a particular party can't attend by an electronic communication platform, you have to conduct the hearing by telephone. You'll all be, I'm sure, familiar with the providers, albeit there's limited availability currently, and a factor to bear in mind within the Court of Protection in particular is that each of those providers has a minute-by-minute cost of the telephone calls to all participants, which could mean that family members and P in particular might well be disadvantaged by that. So that's got to be borne in mind and considered. Consideration has got to be given to hearing impaired participants, and procedural responsibility for arrangements is on the applicant or first represented party, though certainly something that I'm finding, although I can't speak for anyone else, is that courts seem to be increasingly making the arrangements in terms of calling out themselves, because it gives the judge more control over their list, and it's also quite helpful because it means you're not then waiting on the phone or on your link for a long time to be joined by the judge. A short listing matter is that hearings have got to be listed at a specified time. They can't be block listed anymore for that same reason. Security issues. There's obviously a difficulty with regards to the potential for unauthorised recording of hearings. The Coronavirus Act makes it an offence to record a hearing conducted by live link, so there's that disincentive to do it, although the Court of Protection isn't yet included within that. However, what Mr. Justice Hayden says is in the standard order template that he's appended to the guidance is that it includes a prohibition, an explicit prohibition on recording, and a penal notice as well, with a potential for 2 years imprisonment, which should certainly be a disincentive. Transparency is an interesting little issue. Obviously, the ordinary rule, as everyone will know, is that hearings in the Court of Protection are to be in public with reporting restrictions. Of course, the default position that hearings are now to be conducted remotely means that 4C isn't workable anymore, so it's temporarily disapplied, and that disapplication is within the standard order. That also means that for all existing proceedings, existing applications, the transparency order has got to be discharged and specific directions made to accommodate the current situation. It's just satisfied that any interference from hearings not being in public is justified, 10-2, by the risk to public health. And in each case has got to be consideration of whether the attendance of the public and press can and should be facilitated and how that should be done. Recording. Responsibility is that with the party who organised it, and there's a provision that a link of the recording should be sent to the judge immediately afterwards. Attendance of P. So when the usual rule applies, so when P has got litigation friend or Rule 1.2 representative, there's no need for attendance, and P's attendance is a matter for the representatives to consider. One matter that is, where there's some emphasis in the guidance, is that Mr. Justice Hayden is clearly conscious that at the moment there's an enormous strain on resources, which is going to make P's attendance remotely or otherwise even more difficult to facilitate than it might normally be, and certainly it's going to require often staff to support P to attend a remote hearing, and it's clearly implicit, at least in the guidance, as to whether that's really going to be necessary. If a judicial meeting with P is necessary, then the meeting should be recorded and a copy made available to the parties. Litigants in person. If you've got a litigant in person, a copy of the protocol should be sent to them. The responsibility for that is either the applicant or the first represented party. Again, if there's no access to electronic platform, it should be a telephone hearing. The litigant in person's attention should explicitly be drawn to paragraph 23 on court etiquette to ensure that there's no interruptions, and it also should be an agreed mechanism during the hearing, which I think is really important, having had a couple of these hearing litigants in person, where they can indicate if they don't understand something. And certainly conducting hearings by telephone or video, I think as some of you do, if you do advocacy, you have to be even more aware than you might normally be, that what you're saying isn't legalese and is actually being understood, because it's that much more difficult for a litigant in person to make it known if they haven't understood what you've said. Witness evidence, there's certainly an emphasis now on paring down bundles and paring down the documents that are going to be used in hearings, and so there's an encouragement, if there's going to be live witness evidence, to agree the documents which a witness is likely to be referred to and to circulate an additional electronic bundle of those documents to make things easier. We've got to consider screen sharing mechanism as we've got today, because that's going to remove the need for electronic bundles. Just procedural requirements, no requirement for holy book on a remote hearing, a judge can administer the oath. And the witness should be alone with no interruptions. And of course, that's something that's come up a couple of times in discussions we've had this week, because of course there's, with live evidence, and it's untested at the moment, of course there's scope potentially for abuse. So for people to be present, to coach witnesses or influence what they're saying. So I think we'll have to play that by ear. Electronic bundles are now the default position, as physical bundles are unsafe and can't be conveyed in a way that is in accordance with the law. There's also specific guidance on bundles being PDF with essential documents only, which is going to mean, I think, that in some existing cases, the bundles are going to have to be edited quite urgently, which is yet another task for people to do. They should preferably be hyperlinked and searchable, but that's not compulsory at the moment. And skeleton arguments should be provided separately in Word format. Orders, as everyone will know, electronic seals are available and used already in the Court of Protection. One area where there's an issue, which at the moment there isn't a resolution for, is in deputyship applications and orders, because HMRC and banks are still insisting on embossed seals for obviously reasons that are understandable, but that's not currently workable, and the discussion's ongoing about how that's going to be facilitated. But most orders can be effective whilst unsealed, and of course the court can determine that service can be affected by a non-physical means, and the COVID outbreak is clearly a good reason for this to be done. There's a template order attached to the guidance. I would encourage everyone to use it, because I think it's undoubtedly going to become standard in the coming days and coming weeks. And one final thing, the guidance has clearly been written with one eye on issues of legal aid funding, and Ms. Justice Hayden is clearly very conscious that parties are being encouraged to agree matters without a hearing if at all possible, and that may well have involved an awful lot of work, and that work should be enumerated. And to that end, there's, amongst other matters, there is this wide definition of a hearing, which can include the hearing by email. So apologies for talking so fast, apologies for going over my time, but that's my whistle stop tour through the practice and procedure.
No, thank you, Sophie, for that tour de force. I mean, it's a complicated area at the moment, isn't it? Hannah asks this question, which is that, do you think there'll be a uniform approach in terms of platforms moving forward? Because she highlights the fact that in some hearings, especially when they're back-to-back, there are different platforms that are being used by the court.
Yes, hi, Hannah. I think, yeah, well, I think we're sort of finding a way, aren't we? And I think undoubtedly there's going to be a bit more uniformity of approach in which platforms are the most suitable, because it does seem that certainly something like Skype for Business was what was on the judicial laptops. I understand that quite a lot of judges hadn't actually used it yet, and in lots of ways it's an outdated platform. And certainly the platforms where you can use, when you can have breakout rooms and take instructions, are going to be much more user friendly. But that's all going to be dependent on the software and hardware cranking through the system so that everyone's got access to it, and of course on users having access to it too. But I'm sure there'll be a sort of increased uniformity in the coming weeks and months.
Sure. Megan asked this question, which is that, is there a need to discharge the transparency orders when hearings are listed, when hearings are being listed, when it is all hopefully over and we're back to normal hearings?
I suppose it all depends, I think, how long things go on for, isn't it? For as far as I understand the guidance, for as long as the restrictions are ongoing, and for as long as the default position is that hearings have got to be undertaken remotely, and to the extent to which hearings are undertaken remotely and can't routinely be accessed by the public, then the transparency orders will have to be discharged, and presumably if things get back to normal, put back in place again. I've only had a couple so far, but I've just adopted the guidance and provided within the order for discharge of the transparency orders.
Yeah, and it's probably right to recognise, isn't it, that in terms of actually these platforms resulting in effective hearings, I mean, whilst there's a encouragement to agree orders without a hearing, on Skype for Business, it is, and it has been possible to have 2 or 3 day long hearings where evidence is tested by expert witness from experts, and there's proper submissions. I mean, it is possible, isn't it?
Yes, increasingly around. I think you've all got the sort of we're sort of circulating things around chambers, aren't we? And that there clearly are quite complicated hearings, and also things like mediation that are going on, where that's all being conducted remotely, and it seems broadly to be happening quite successfully. Super.
Thank you. There are a lot more questions as everybody else, but I'm going to stop there so we can move on to our final presentation. But thank you very much, Sophie. And our final presentation is from Eliza, who's going to talk about issues of self-isolation, deprivation of liberty, and issues with contact.
So I have one of the unenviable tasks of trying to condense down into 15 minutes, one of the most challenging and perplexing aspects of the new coronavirus regulations and emergency legislation, which is how to apply the principles of social distancing and self-isolation, and the consequential effect this has on restrictions on people's contact with their loved ones for people that lack capacity. And so those are the 3 issues I'm going to be discussing within the next 15 minutes. In terms of those people that have capacity, everybody that's dialing into this seminar, no doubt we will have all read and digested the guidance and the new law, and we'll go about applying the new law in our everyday life, taking those risks that we consider to be measurable or proportionate in how we live our life, whether that's going to the shop for something that's not strictly a necessity, or popping into the office when it's not strictly necessary to do so. But I foresee there's a real likelihood that those people that lack capacity will experience more acute restrictions during this period than their capacitous counterparts, because of the temptation to apply the restrictions in a much more absolutist fashion when we're dealing with people that lack capacity. And really in this talk, I'd like to suggest that when we come to apply the restrictions within the context of the MCA, we need to make sure that decisions are made and rooted in the principles of the MCA, with principles of lawfulness, least restrictive principle, promotion of autonomy and best interests being at the root of the decision making, rather than people making decisions as if they're simply an arm of the police enforcing the regulations. So the first issue I want to come to is the issue of social distancing. This is brought in by Regulation 6 of the Health Protection Coronavirus Restrictions Regulations 2020 and applies to everyone. And actually, could I just check that whether people are seeing my face on the screen, because I'm still seeing Sam's face on my screen. Are people seeing my face on their screen?
Yes.
Yeah, okay.
Seeing lots of ones.
So these restrictions apply to everybody, whether you have capacity or not, and essentially provide that during the emergency period, no person may leave the place where they are living without a reasonable excuse. And what constitutes a reasonable excuse is set out within Regulation 6, and there are a number of different excuses, but the most applicable are likely to be those set out on the screen: to obtain basic necessities, to take exercise alone or with members of a person's own household, to seek medical assistance, to provide care or assistance to a vulnerable adult, and to travel for the purposes of work or voluntary services where it's not possible to work from home. There are additional restrictions under Regulation 7, which prohibit gatherings of more than 2 people, except with those, and again, there are a number of factors, but the most relevant are that the people may be within the same household or gathering for essential work purposes. Now, we had an interesting discussion, certainly within our team, as to whether we're all subject to deprivation of liberty as a result of these regulations, or whether it amounts to a restriction on liberty. And certainly the collective view that we came to was that this is really a restriction on liberty, insofar as we are still able to leave the house and to move elsewhere if we wanted to do so, and we're not under continuous supervision and control. And I'd be interested to know what other people's thoughts about that are. But certainly if we proceed on the basis that these regulations amount to a restriction on liberty, then the next question is how we apply those restrictions for people lacking capacity. And rather unhelpfully, both the regulations and the Coronavirus Act itself are silent on how this should be applied for people that lack capacity. And there are no new powers that are imported into the MCA that allow decisions to be made on behalf of an incapacitated person to enforce the restrictions. There is guidance that has been issued on the government website for care homes, supported living providers, and for home care on how they approach issues of self-isolation and other relevant issues. But those are silent on how decisions are taken and enforced for people lacking capacity. So what I suggest is that essentially we have no other choice but to go back to first principles. And those are the steps that we're all familiar with. So assessment of capacity: can the person understand the issues regarding social distancing and the issues pertaining to the pandemic? If not, for a best interest decision to be taken as to what restrictions should be applied and how they should be factored into that person's care plan. Now, I think we probably do have to proceed on the basis that the care plans should be lawful, obviously, and should comply with the coronavirus regulations. But it's also important that we're discussing, or people making these decisions are discussing the measures with P and factoring their views into the arrangements and making sure that the plans are still person-centred and that we're not overly zealously applying the regulations. For example, there's been different comments made by politicians suggesting that people should be going out to exercise only once per day or up to an hour. And no doubt people will have seen the commentary in the news about police overzealously applying the regulations. If you actually look at the regulations, there's no restriction on how often you can go out for exercise per day, or for how long, or within what parameters, or how often you can go shopping, for example. However, I've certainly come across a number of cases in the last few days where I've been told that P is now not going out at all because of the government guidance regarding people leaving care homes. So in terms of enforcement, there's obviously then the issue of what happens if P objects to the measures that are required to enforce the social distancing regulations. If somebody is in a care home or supported living environment under a standard authorisation or a community DOL, then that potentially gives greater flexibility, obviously, in preventing a person from leaving premises. If there's no authorisation in place, then we're essentially reliant upon the defence to liability, which is set out under Section 5 and 6 of the Mental Capacity Act. Namely, there's a defence to liability if D doesn't act reasonably believing that P lacks capacity and that the act is in their best interests. But in this case, I would say that particular attention needs to be given to Section 6.3, which deals with the use of force or restraint, which must be proportionate to the likelihood of P suffering harm and the seriousness of that harm. And so I moot the question: if P wants to go out, for example, to a shop to buy something which is not a necessity, or wants to go for a walk with a friend who doesn't have corona, is that likely to justify the use of force or restraint to prevent them from going? And arguably the answer would be no. So given there are no additional powers afforded to decision makers under the MCA, the next place to look is what does the new regulation provide by way of additional powers? And those powers are vested in the police, not in everyday decision makers, to essentially direct that a person return to the place where they are living if they're in breach of the regulations, or remove that person to the place where they are living. And moving on to the next slide, you can the police can use reasonable force to do that in the exercise of that power, and it's an offence to contravene the regulations punishable by a fine. So it may be for people lacking capacity that the police wouldn't charge them with an offence under the regulations, but they could still exercise the powers to return them to their place of living if they are breaching the regulations in a way which requires coercive measures to control. So when it comes into how we factor this into care planning, I would suggest the starting point is that the care planning should be in accordance with the regulations, but we need to consider how far we can go under the MCA to enforce those restrictions. And if seriously coercive or restrictive powers are going to be required, then reliance should be placed on the powers issued to the police under the regulations, rather than people assuming those powers themselves without any lawful authority to do so. So moving on to the second difficult issue, which is self-isolation. These are measures that apply where somebody is symptomatic or have been in contact with someone who is symptomatic. And the government guidance is that people are required to self-isolate for 7 days if they have symptoms, or for 14 days if they're in a household with somebody with symptoms. And I think we can probably all agree that being confined to their house in self-isolation almost certainly amounts to a deprivation of liberty for that period. In terms of guidance or additional law that is available to enforce that self-isolation for people that lack capacity, there are a number of sets of guidance on the government website that deal with self-isolation in different settings, but none of them deal with how the same can be enforced for people that lack capacity. The guidance on residential care suggests that individuals should be self-isolated in their own room, and the rules on household self-isolation do not apply. Moving on to supported living, really all that's said is that if someone's presenting with symptoms, then steps must be taken, their well-being must be assessed and appropriate action taken, whatever that means. And in terms of whether household isolation is necessary, it's important to consider the physical layout of the supported living environment. But again, it's silent on how we enforce this for non-capacitous people. If you then look at home care, all that's said is that if someone's presenting with symptoms, then extra care should essentially be taken by carers when caring for them. And that where peers part of a household self-isolating, the care continues, but with efforts made to avoid the infected person. And again, the guidance is silent on how self-isolation should be enforced for the non-capacitous. So again, in the absence of any additional powers or additional guidance dealing with how to enforce these issues for people lacking capacity, I would suggest we have no choice but to go back to first principles and the law as it currently stands. And when we come to deprivation of liberty, the starting point is always Article 5 of the European Convention of Human Rights, which is that everyone has the right to liberty and security of person, and no one shall be deprived of his liberty, save in the following cases, and in accordance with a procedure prescribed by law. So we're very used to Article 5.1e dealing with persons of unsound mind, and now obviously the issue of spreading of infectious disease is coming to the fore. In terms of then how we deal with this under the MCA, the starting point is obviously assessing capacity and making a best interest decision if that person lacks capacity about self-isolation. But Section 4A of the MCA continues to apply, so that D may not deprive P of their liberty, save for under a dole's authorisation under Schedule A1, a decision of the Court of Protection under Section 16.2, or if it's necessary for life-sustaining treatment or a vital act under Section 4B, but that must be pending an application to the court. You can't just use Section 4B to dole people without making that application. So when it comes to the practicalities of this, obviously we can consider using an urgent or standard authorisation where that's applicable for people in care homes and hospitals. If someone's in a community setting with a community dole, then it may be appropriate to increase the restrictions. But obviously under the usual re-ex order, if restrictions have to increase in an emergency, those restrictions can be put in place, but should be followed by an application to the court. And usually a COP 9 should suffice, setting out what the additional restrictions are. Where there's no authority in place, then I think we have to be realistic that where the arrangements are not objected to by P, it may not be realistic in the current climate for applications to authorise the dole to be made in all of those situations. And it may end up being the case that the arrangements are simply put in place and not objected to by P, and it's unlikely that there would be any claim arising at a later date. The difficulty is where P meaningfully objects to the restrictions and that coercive practices are going to have to be put in place to enforce the self-isolation. And in those situations, I would suggest there are two options. Either an application needs to be made to the COP to authorise the arrangements, and it's likely that the court would be responsive in terms of emergency applications and dealing with those remotely, as we've heard, or the procedure for detention set out in the Coronavirus Act 2020 needs to be applied. And these are additional powers that are vested in the police to enforce self-isolation where that's required. So Schedule 21 of the Coronavirus Act provides that the police essentially have the powers to require a person to go to a screening and assessment place for 48 hours or up to 48 hours. And they can take a person to that place. And then following assessment may require a person to go to a specified place in isolation from others for a specified period, which is up to 14 days. It doesn't say what that specified place is, and it may well be that person's own home. And there's discretion to identify where that place should be. And then once that's in place, the police have the power to remove a person to that place, to keep the person at that place, and to, if they abscond, take the person into custody and return them to that place or another place specified. So there are additional powers available to enforce these very draconian measures, and they are vested in a police constable or a public health officer under the Coronavirus Act itself. Crucially, under paragraph 17, there is a right of appeal to a magistrate's court to challenge the period of detention, which makes this procedure compliant with Article 5.4. And in that way, it's obviously different than if decision makers and carers are simply assuming their own powers to deprive people of their liberty and enforce self-isolation, or where the relevant person would have no power or right of appeal. And that process wouldn't be Article 5.4 compliant. So essentially, in terms of enforcing self-isolation, my advice is to use the powers that are available under the MCA, and if more coercive or restrictive powers are required, to invite the police to exercise their powers under the emergency legislation. Then finally, just briefly looking at contact restrictions. Obviously, both social distancing measures and self-isolation has a real and meaningful effect on people's contact with their loved ones, which no doubt we're all experiencing at the moment on a day-to-day basis. There's currently very little guidance on how issues of contact should be dealt with, save for the guidance in relation to care homes, which says that external visitors should essentially be excluded for this period, obviously because of the risks of the virus spreading around very vulnerable residents within a care home setting. There isn't any equivalent guidance for supported living providers or home care. But my experience so far has been that most supported living providers are issuing an outright ban on any contact taking place with family. In terms of decisions in respect of contact, again, capacity still needs to be assessed in respect of those issues, and if P has capacity, they're entitled to take their own risks in respect of those issues. Otherwise, a best interest decision needs to be made. And whilst care providers should not be facilitating breaches of the regulations, I do think it's important that care is taken not to over-interpret the law. So, for example, there may need to be some creativity in respect of the issue of contact. And this is moving on to the next slide. For example, could P go to a shop with a family member? Is that prohibited under the regulations? Facilitating Skype and FaceTime. I think this is something that care providers are trying to facilitate, but the reality is that for many people with different types of needs, it's not a meaningful form of communication. Similarly, we may need to ask whether family and friends fall in the category of offering care or assistance to vulnerable people. I was certainly dealing with a case this week with a young man who self-harms on his arms and will only let his mother dress his bandages, and his parents are still being permitted to come into the supported living provision to see him and to dress his bandages. And there's different strategies that can be put in place to manage risk, such as taking temperature of people coming to visit or washing hands on arrival, rather than outright banning all forms of contact. Obviously, if there's a dispute, efforts should be made to try and resolve those issues collaboratively. There is a practical issue in that care providers often hold the trump card that they can simply say that they will withdraw their services if they don't feel the provisions in place in respect of contact are safe for their workers. But sometimes it is appropriate to have some pushback because of the tendency to apply blanket policies in respect of excluding all forms of contact, even when that's not necessarily appropriate, even if those are attractive policies. And ultimately, if no resolution can be reached, then in certain situations an application to the court may be required. Although whether those applications will be prioritised in the current climate is a matter that we will have to wait to see. So that concludes my skip through this part of the seminar.
Thank you very much, Eliza, and thank you for speeding up through the time. So I've got, again, several questions that have come through, probably more than others, but on this topic, as you can imagine. So I'll try to distill the most common ones. One question asks this, that if a person lacks capacity regarding social distancing and contact, and restrictions are in place, should a local authority review the DOLs in place to include a specific COVID-19 restriction, or apply to the Court of Protection for a one-off order or authority regarding any care planning around restrictions?
So is the question essentially that if restrictions are being put in place further to the crisis?
That's right. Should they review the DOLs in place to include a specific COVID-19 restriction, or apply to the Court of Protection for a one-off authority?
I'm not sure I completely understand the question on whether we're envisaging a situation where a restrictive framework is already in place. If, for example, there is a standard authorisation in place and the restrictions are heightened because of the COVID-19 situation, then I think it would be wise, if additional restrictions being put in place, for the RPR to be notified and the supervisory body to be notified that the restrictions are more heightened, so the supervisory body can make a decision as to whether to conduct a review of the DOLs, and the RPR is on notice that the restrictions have heightened in case a challenge is required. With a community DOL, obviously the REX order provides that additional restrictions can be put in place in an emergency, but an application to the court should then follow. And given those are usually orders with liberty to apply, it should be capable of doing that fairly quickly with a COP9, which has minimal cost, rather than a one-off application. In the other...
No, carry on, I interrupted you.
I was going to say, in the other situations generally where there's no authoritative framework in place, I think it goes back to what I was saying, which is that if P doesn't object and everybody's in agreement as to how things should proceed, from a pragmatic perspective, I envisage that those will not be the cases that are being prioritised in terms of applications to the court. But if P does object and restrictive measures are being applied, either I would suggest there does need to be an application to the court, or the police's powers needs to be relied on to return and enforce the restrictions.
Got it. Thanks very much. Lauren asked this question, which is that when looking at self-isolation and social distancing, what do you think the relevant question is when assessing capacity? So do you think that there are issues that P has to be able to understand about the risks of COVID-19 to himself or herself or others?
I think that's precisely the issue. What are the risks of COVID-19? What are the new laws saying what we can and can't do and why, and what the implications would be effectively of breaking what is now law and the sanctions that may apply. Obviously, there may be slightly different issues in respect of different people if they have particular health needs or if they have family members with particular health needs. But those would appear to be the core relevant issues.
And I suppose under section 3.4, the reasonable consequences or foreseeable consequences of making a decision one way or the other.
Yes.
Yeah. One final question is, in respect of RPRs, Rebecca asks, how on earth are they supposed to meet their duties when they're not able to meet with P and consider their environment?
Well, it's difficult, just as it's difficult for us all conducting hearings remotely and best interest assessments taking place remotely. But I think the starting point is to maintain telephone contact or communication via alternative means, to request records electronically, and to undertake whatever inquiries can be made through remote technology. Obviously, it's not possible to walk around the care home, but a lot can be picked up through speaking with people remotely and speaking with the relevant people in their lives. And I would suggest the same for solicitors who need to get P's wishes and feelings and to talk to the care managers or staff, that should still be taking place, but by telephone or any other measure.
Thank you very much. Again, there have been lots of questions, which I think, given the time, I'll stop there. Thank you, Eliza, for that informative talk. And thank you, everybody, for being here and trying this new interactive way of seminars and lectures. We hope it's been informative to you all. I think there are a lot of areas we haven't covered that we perhaps, if we had a bit more time or perhaps another session, we would like to, which especially in relation to CCGs and healthcare obligations, because some of you will be aware that under section 14 of the Coronavirus Act, there are amendments in terms of the obligations in respect of NHS continuing healthcare. Some of those duties no longer exist. So that's worthy of note for those of you involved in that. And in respect of life, end of life issues, hot off the press is the British Medical Association's COVID-19 ethical issues guidance, which came out yesterday evening, which essentially, and I'm looking at this in one of my cases tomorrow, it essentially says that there is a new adoption of a capacity to benefit quickly test, a capacity not in relation to mental capacity, but essentially saying that most unwell patients may be denied access to treatments such as intensive care or artificial ventilation, but recognizing that that may result in indirect discrimination, but they say that that's actually achieving a legitimate aim under the Equalities Act. There's no reference at all in relation to those who lack capacity in that guidance, so that's going to have some ramifications. As I said at the beginning, we are here to help as far as we can do, because these are extraordinary times. And if you want any further assistance, just ask us. There is a dedicated website, which Simon referred to earlier, operated by King's Chambers, dealing with all different types of issues relating to these times, not just mental capacity, but other civil proceedings and well-being. The contact details for Mark are there, his email address and telephone number, and contacts us directly. You have our mobile details, you have our email addresses, so if you have any questions, don't hesitate to get in touch. But again, thank you for being here. We hope you all keep well and your families keep well in the future. Thank you very much.
Thank you.
Thank you.
Thank you.
Thank you.
Thank you very much.